Hey, everybody, and welcome to the Cathleen Scott podcast. We appreciate you tuning in. Should you file a lawsuit against your employer? Filing a lawsuit is a really important decision, and we're going to talk about that today, the pros, the cons, the emotional aspects, sort of the non-tangibles that you might not have thought of. So I'm joined today with Anne Tomasello, good friend and senior associate at the Scott Law Team, to talk about when should you sue your employer and when do you hold off?
Oof. And should you do it while you're still employed?
Yeah.
Right?
That's uncomfortable.
That's the question. But there are circumstances where if you don't do it within a certain period of time, 300 days for discrimination cases, you might lose your right to bring those claims. So, it's an interesting topic. It's one that a lot of people feel, uncomfortable clearly while they're still employed,
Yeah.
and then when they leave their employment, it gives rise to all other things like, will this keep me from getting a job? It's public record if they see that I sued a former employer.
So let's unpack that a little bit. So there's some things you can file, like administrative proceedings, right? Like EEOC, National Labor Relations Act, admin things like unemployment. Those are not going to be generally available to the public, right? So that's probably a little less scary, I guess. But still, you're still bringing a claim against your employer, and they're going to find out about it, and you have to work there, and that's uncomfortable. But compare that to like filing like an actual lawsuit, like down in the court. In the old days, I'm really dating myself, we actually would go to the court and actually file the lawsuit, bring our check for the filing fee, and then get the subpoena issued. So that's a bit different, right? That's a little bit more serious.
I think anytime you're filing a lawsuit, it behooves everyone to kind of take a step back and think about not just what, because you want retribution or you want to get paid for something that you think you're owed, but also just the mental toll and the physical toll of putting yourself through, the trudges of a lawsuit. And I think that's what a lot of people don't understand is coming, the discovery aspects and the exposure to very personal, private things.
Yeah. So first is just the publicity of actually filing it, right? Your name's out there forever in the ether. If you file a federal claim, you can Google your name and it's going to show up, your name versus the employer. But you make a good point. There's an emotional toll too. It's like sometimes bad things happen and you find a place for them, you can move on. But when you file a lawsuit, it's like you're saying, I'm going to relive this bad act, this sexual assault, this discrimination, this wrongful discharge. I'm going to relive it for the next 2, maybe even 4 years, depending on how long the case lasts.
And it can be healing. It can be empowering to stand up for yourself and advocate for yourself in that way. And I think that it's important to think about, possibly other therapeutic interventions, meditation, things like that can help you through a process that it can be traumatic in some ways at times.
Yeah. And I think as lawyers, we can try to use, at least I try to, in my cases, I try to use that bravery, that like sticking your neck out, that suffering that you kind of create by filing the lawsuit to kind of enhance the damages that an employee can receive, right? Because it takes a lot of courage to do that, to put your name out there. Every future employer's probably looking at that. I mean, we live in an information age where it's like, if you want to find out something about somebody so fast, you're just like, da-da-da. And that lives with you beyond the case and beyond any recovery. And, so I think we talked about the publicity of it. That's a personal risk too. You make a good point about getting some help to deal with that. That's really stressful. But there's, another risk that I think people might not appreciate, or if they do, I really think it's important to talk about it. There's a winner and a loser in every case, right? So your odds are always 50-50, no matter what kind of great lawsuit you have. I mean, how many times has someone come in and sat down with you and they're like, if I have $1 million case and we got to file this because we're going to get $1 million,
Yeah, one of the things that we talk about a lot with potential clients who come in is the cases that you hear about that are worth $1 million or where they're awarded $1 million, those cases are few and far between, which is why they're newsworthy.
That's a good point, right?
Most cases don't settle anywhere near that, and especially in Florida. These cases, the damages that are available, for the most part in discrimination cases, in wage cases, they're lost wages. And not only do you only get the money that you would have made had you continued working there, but you have a duty to mitigate your damages. You have a duty to get a new job and find a new job and replace that income, even if it's not at the same level.
You mean you just can't sit home and like eat bonbons and watch we used to say soap operas. Nobody watches soap operas anymore. Look at YouTube all day.
Doom scroll. Yeah. No. But I do, but people think that well, I'll just wait until this lawsuit is concluded because I'm so stressed out, or I want them to pay more, and that's just not the way it works.
So, and when we talk about the risk, like we don't know how the outcome. Nobody can tell you with certainty the outcome of a lawsuit. You kind of give that away. If you don't settle your claim, you give that away to a judge, and then if you get there, to a jury. Right? That's finality is not a product of litigation. It literally can live forever. People can keep appealing, file a motion set aside. It just goes on and on and on and on. And sometimes you file enough things, you throw enough pasta noodles at the wall, something might stick, and what is a great case might turn into, well, this one judge saw it differently. So I think so the risk of that is not just losing. And this is something we try to make sure our clients know before they do this. It's not just losing your case and getting nothing. You could actually owe something to the other side, depending on the type of case, right? I mean, you could actually owe fees, cost. It's pretty scary business.
Yeah. And, all of our, of course, for the employer clients, the cases that have, prevailing plaintiff fees as opposed to prevailing party fees, I've never, ever met anyone who says, on either side of the table, who says, yeah, we screwed up. We did something wrong.
Right. Where do I sign? Yeah.
Right.
How much can I pay you to make this right?
And frankly, in Florida and in at-will state, you have quite a few defenses at your disposal. And so a lot of times it does drag on for a length of time. And I think that that's important for everyone on both sides to know and remember.
Like if you could have $10 in your hand today to go buy something versus waiting 3 years to get that same or a fraction of that. I mean, that's the real thing too, right? And I think a lawsuit is a lot of work. It's a lot of work for lawyers. Pre-suit, we do a good investigation and we try to get the case positioned to get settled. And if that doesn't happen and you get forced into filing a lawsuit, from a lawyer standpoint, the work quadruples, if not tenfold. I mean, right? It's just, there's so much more to do. There's depositions, there's subpoena documents, there's getting all these things. But from the client perspective, it's not just your lawyer that has a lot more to do. You have a lot more to do too, right? I mean, you've got to provide all those documents. You got to do all that work.
I think we should dive into that a little bit because one of the biggest things that I see is that clients don't understand, and we do our best to give them heads up and send them letters, but they don't understand how invasive discovery can be, especially if you're claiming emotional distress damages. And that opens a window for your former employer to get access to your very private medical records.
Therapy records. Past therapy records, past medical history too, right? I mean, that is fair game. When you file a lawsuit, you put your personal situation, your personal medical health at issue. And so the employer has a right to discover that. And then when you seek emotional distress damages, your employer has the right to say, well, where did those damages come from? You got divorced last year. You had a tragedy. You suffered a medical condition unrelated to your workplace that could have caused emotional distress damages. And so it is turning. It's like turning the rocks upside down and all of your skeletons coming out. So that is a factor, and that is scary, and that is really. It's almost like a second violation of the action that happened as you're going forward.
It really is. I think in some ways it can be, and we do our best to try to, minimize the invasiveness to the extent we can. For our employee clients, particularly ones who have been, who have experienced very traumatic things at the hands of their employers or allegedly at the hands of their employers. And so, I think that it is important for people to understand that, though, that what they're opening themselves up to by filing a lawsuit.
And at the same time, I do want to say we've kind of painted this picture of like all the negatives that in litigation brings with it. But, there is a reason and a time and a place and a reason to file a lawsuit, to do good work, to hold employers accountable. What we're saying is you just really need to have your eyes wide open as to what that looks like and how long it might last, that personal exposure that's out there to you with your name out there. To your great point about, having to relive it and the emotional trauma of that and the discovery aspects.
Look, sexual assault and and discrimination, those things are insidious. They're not things that people do out in the open for the most part. They're not things that people do where it's open and apparent and it's done in front of other people. These things tend to happen when after hours, stay behind, help me out. And then there's no one there. But what we find in a lot of these cases is one person will come forward and have the strength and the bravery to bring forth that claim. And then the other side's skeletons start coming out where
yes, that's the fun part of litigation.
Yeah. I mean, for us, it's definitely fun. And I think it's, but it's the reality of when you have a case like that, people, what do they say? A tiger doesn't change its stripes,
right?
Yeah. And if one person has experienced this, chances are other people have too.
Yeah.
Maybe.
And that's the powerful part of litigation. In Florida, we don't have rights to personnel files. So when we're doing a pre-lawsuit investigation, we're not able to get a lot of stuff. Like we can't just make the employer give us your personnel file or the personnel files of the bad actors. But when we have the power of subpoena, we can get that great information that, we can get the metadata, we can subpoena and get those emails, threads, and find out who the other people were who complained about the bad actors and get to that really good stuff. And that's the fun part about litigation. I love that our firm I feel like we do a really good job of leaving no stone unturned and unearthing every crumb that there is out there.
Go into the LinkedIn and find out who worked there before and call them to see what their experiences were. It's, that's the investigative part is really something that I think we're all into, which is why I think we're, curious by nature and, to give a pop culture reference, be curious.
So litigate if you have to, but know the risks, that the outcome's uncertain, that you're in for the long haul and it's unpredictable and you're not in charge, right? That's the hardest part, I think, for clients. It's their case, but they're not in charge of it. We turn that over to a judge and to a jury to decide, how that evidence is going to play out.
What I will say about that, though, is that we also take on for our clients a lot of the burden. Mm-hmm. I think people tell me, at least, that they feel relieved that they have somebody fighting for them because they know the employer has somebody fighting for them. And so we can take a lot of that burden off of them, and they know that their rights are going to be protected, at least and so far as within our abilities to do that. Yeah.
And we can really hold people accountable especially publicly accountable by filing lawsuits too. And that often is what encourages the largest settlements, right? Usually litigation is what motivates the biggest settlement. So go forth and litigate, do it with your eyes wide open, and definitely with a reputable firm.
Yeah. Knowledge is power.
Yeah.
For sure.
It is. I'm Cathleen Scott. I'm here with Anne Tomasello. Thank you for joining us on the Scott Law Team and the Cathleen Scott podcast. Thanks, everybody.